Thirdly, documents records for handing over the possession of the city. I repeat and request, I said you very clearly, whenever you are going for any kind of the documentation or taking over the possession, you should have a proper video recording for that. A. B. Wherever you are just going, please try to take the signature, change the security if required, change the each and every the passwords of their bank accounts, passwords of their websites. See to it that everything should be in your control. Otherwise, what happens? Even the camera's password, you have to change now because of the fact that ultimately, whatever you are doing, somebody may try to just changes the camera's visions and all those things. Then you may be coming under the problem. So my request to you, when you take over the position, it is your duty to see to it that each and every passwords and documents should come in your possession. Wherever it is a precious documents, keep in a proper lock and key and change the key. Always try to see to it that passwords are to be changed. Always try to see to it that video recording has to be made right from the beginning. Video recording has to be kept with you, as well as all the cameras which are there, CCTV cameras, even their passwords, everything is required to be changed and kept with you so that tomorrow somebody will not make any kind of a misuse of it. So you should not be covered under trouble. And therefore, these records and documents are more important wherever you take the position of the city. The most important part then now comes. So now you are assuming that you have taken a full position of the city. See what is happening. Whenever you are just documenting anything, after even the COC, during the course of COC meeting, what happens? We try to write down a minutes. But I've seen in number of cases that insolvency professionals are not making proper representation in the minutes, and therefore executing authority always questions you that why this resolution does not specifically state that the COC, all COC members or a majority COC members have accepted to go for a say extension of the CIRP, or they may say whatever the IRP to IRP to the RP. So proper wordings are required to be taken into account whenever you are doing such kind of the situation. This is the most important part, because otherwise everywhere judicial authority will ask that where is the resolution of so and so thing. We see that at page number 9 or page number 19 of my application. Page number 19 of the application, when we look at the specific resolution, at that point of time, certain words are missing, and therefore, in that eventuality, there will be the next date of hearing will be given, and you will have to also change the entire this minutes, get it signed again, and go to again to the education. So my only humble request to my all friends, though they must be company secretary, they are good at the drafting. However, in spite of that, your resolution has to be clearly specify what object that you are trying to say. So that's the most important. The most important aspect which I have seen in some of the CIRP, that generally RP tries to just work by himself before the NCLT, Educating Authority, because he is also appearing before the NCLT on a regular basis. He feels that I will make an application and I will go and represent my case. Section 19 application for non-cooperative run by the promoters. I request all of you, do not make such a mistake. We need to try and work out a solution that let the other person to represent you, because if you're making some mistakes, the other legal other advocates or a lawyer or a other professional will definitely help you in making your claim properly. So do not think, and this money is to be paid by, even if you have to make an application, that has to be a part of a CRP cost. So do not try to save the cost of the company, corporate data at your risk. Always try and have some legal person who understand the educating authority situation, and then he goes before the double A. You remain present during the course of the, because nowadays it has become a mandatory for the, by the IBBI, that in all the cases wherever these certain things are required to be taken decision by the double A, then RP or recruiter is required to remain present. So you remain present there, but do not say that I will make an application and I will be a person in person who will take care of these aspects only. No, don't do that. So that anywhere you are making some mistakes, that mistakes can be rectified by the other person, and ultimately you will not have to blame. Secondly, sometimes the double educating authority asks you some questions as a representative and as well as RP. Then you are, if you have to just go and look into something and then come back to the double A, you can have some kind of the rescue for that. Here in this case, when you are doing everything, it seems difficult for you to just defend yourself. So my humble request to all RPs, do not try to take the risk of just going and representing yourself. Coming back to the next aspects, so wherever you require a police permission, you cannot just directly go to police and do that. You have to go to double A, take their educating authority will definitely tell you that, okay, fine, this permission and we will try to work out. You just, they will direct to the police to escort you and just take the position because there is a non-cooperation. So these are the requirements which you have to understand, and do not try and take up the risk at your mind. Though you may be legal luminaries, though you might be defending a lot of cases, it is like this: doctors will not give injection or he will not treat his own family. This is what we need to understand. We are doctors for ourselves, therefore I will not give the injection to myself. Let the others to do that, because there, if I make some mistake, the others can rectify. So my only humble request to all of you, please be careful of that. Coming to the next aspect, the claims, the most important part, difficulty in deciding claims. Basically, what happens where security structure is complex, dispute in the security structures, or even also the claims made by the creditors, what happens? If required, take the opinion of these somebody experts. Here also, you have a right to take the opinion after consulting COC. So let it be, your cost has to be ratified by that way. So once the cost is ratified, you can go to some experts, explain that this is a situation, what way that I can do. Because security structure is very complex and there are a lot of disputes in the securities also prior to your appointment. In that eventuality, whatever the claims that comes to you, you might be thinking about rejecting it, or you might be thinking about the accepting it. Whatever that you want to do, try and take the specific help of other person also who are experts in the claim if required, or take the legal opinion, or ask the promoters also. Say that what is the situation, what was there actually. So you please take the proper letter from them. What way that he was trying to take this security. It is possible that he might have understood differently and he might have done differently. Then you have to go to the bankers also, the secure creditors. They might also have a kind of a situation as of now different, because somebody might be saying I have a pari passu charge, somebody might be saying I have a first charge, somebody might be saying I have a second charge, somebody might think that originally I have given a permission for second charge, but now that permission, because my money is already completed and then I have gone for restructuring, therefore this second charge is not valid. So such kind of situation will come. A lot of disputes will come in that way. Such disputes are required to be taken care of separately, and do not try and decide by yourself. Any claims which comes to you. See, basically you have various things also, that claim accepted. Second thing, claims received under the verification. Thirdly, claims rejected. Fourthly, claim belated received and therefore not considered. Fifthly, you can say that claims are not at all received. So various things are there. You are not liable for such things, certain aspects, but you need to be very careful when you are rejecting claim. Before rejecting claim, You have to go in depth of that, try and have a proper paperwork with you. So tomorrow somebody will go to the NCLT and state that he has wrongly rejected, you should have a proper paperwork done with you and proper records and evidences are there with you so that you can say that I have rejected the claim either as a secured creditor and kept it as an unsecured creditor, or I have rejected fully. So why and on what basis? The bases are required to be there. Say somebody says that I have given you a ledger account stating that this is the ledger account and these are the claims. Now, if you have some doubt that the said ledger is not directly matching with you, you need to ask for the evidences also, if required. Because at a point of time, you might not be having a complete data or the records of the CD. So when you are looking at the claims, yes, if the auditor has already accepted, if your grouping properly available, from that grouping, you can say that ABC company is of 10 crore rupees lying here also, is claiming for 30 crores. Why the difference 20 crores? So you need to go in depth of that, work out a solution, go in the proper communication, try and have a proper records and evidences with you, ask for the complete records. Till the time you're not satisfied, do not accept the claim. You keep it as a claim under verification. This is the most important part which you need to understand. For a financial creditor also, secured financial creditors, look at the security aspects also. Unless and until the security aspects are very clear, then you cannot do that. And at the same point of time, say, for example, there are two banks, assuming that bank A and bank B. Bank A, as I say, 50 crore, bank B has 30 crore principal amount. As on the date of CIRP, the interest of the bank A is say 10 crore. And bank B has given interest up to the date of claim. That is after the CIRP, when you have invited claim, another 2 months or 3 months. Then normally it could have been, say, for example, 3 crore, but it could have, he said 3.5 crore. So you need to take up the same day claim. Do not try and just take the claim the day on which the company went to CIRP. Because after the CIRP, that claim is not considered by you. So only up to that extent. So 55 and 33 is to be taken, and do not consider 55 and 33.5. Otherwise, again, that may create a complication for you in future. So you have to be so careful. And on what basis that you have derived this claim, why you have accepted or rejected the claim, you need to have a proper justification with you. Otherwise, you have to face the legal music. You have to go to the every stage before the NCLT. So I request all of you to be careful while accepting or rejecting the claim. Ensuring the going concern aspects of the CD. This is the most important part. Normally what happens? We understand that. Why person goes to IBC? Basically, either there may be financial crunch or liquidity crunch, and there are chances. Generally, we do not say on all cases, but almost even 70-80% cases, there may be a liquidity crunch, and therefore the company may not be able to work properly. Or they may not be having a specific, what you call it as the working capital to sustain themselves for a long time. Under the circumstances, you may not be able to continue the CD as a going concern on a longer term. So at that point of time, you are always going to be in trouble how to ensure the going concern. So various things. A, try and recover the data of the CD and see to it that the CD can go as a going concern. B, you may go and raise the additional funds, which is always a priority over all other funds, but that should be after approving by the COC. Everything has to be ratified by COC. Please do not take any risk. If anything which is not ratified by COC, there you will have always a problem. So my humble request to everyone is that wherever anything is required, either ask the COC members if they are secured creditors, they say that, sir, can you give me some money which is a priority charge over everyone? So COC, one of the member agrees, then put up before the COC, and then confirm with them so that he gives the money. Others will not object when the money will be distributed. So you have to see to it that concern should remain as a going concern if the CD is working. For that, you need to take proper help and support of the existing management, existing system, existing customers, existing suppliers. You can say suppliers also that whatever your erstwhile dues, they are kept as particular level. Whatever the today's dues, you will get on a regular basis. However, you need to go and support us so that the company's working can go on. Then only then you can get the money. Otherwise, you will not get the money. So you as a RP or IRP will have to ensure that the CD should remain as a going concern for a longer period. Had it been the case that CD is a closed down unit, manufacturing activities are going on as of now, then in that eventuality, your task is otherwise simple, but it is going to create a complication because it will not fetch a good money, and that may create a complication. So in the new resolution applicant, you have to find out a resolution applicant who may not be interested, and the 100 crore assets may go to, say, assuming the 100 crore assets may fetch you 40 crore, 30 crore, 20 crore, as the case may be, will not be able to fetch good money. So going concern is the one aspect. Second thing, most important, when we say about the assets, the quality of the asset should not also be deteriorated. The worst thing is the copyrights and trademarks, intangible assets, goodwill. The day on which the company goes to see, this is again, I'm saying that Indian mentality, or if you look at our system, that when company goes to the IBC and section 7 or 9 application is accepted, the people at large, particularly the customers who are the regular customers, also will not feel like to work with this company. So their goodwill will be deteriorated very fast. This is the assets, trademark and goodwills are the assets which are deteriorated very fast. So you have to be very careful that as early as possible, the company should be revived. Otherwise, you will feel that Jet Airways was the name. Now there is no Jet Airways. People of the new age may not be knowing that what is Jet Airways. So my humble request, or what is the Kingfisher? So these are the situation where you have to ensure as IP that company should remain as a going concern. If that will not remain, it may create a complications also. So try to raise the funds, having a priority charge over all other security creditors as of now, and see to it that company should remain a going concern. Then only the company will be able to fetch sizable goodwill amount or a trademark. That's otherwise those intangible properties will go haywire. Now, when we talk about the beginning of the CIRP, what happens? It is possible that some of the banks might have kept a surface and they have taken the possession of the CD. The moratorium has started by the NCLT because the day on which you are appointed as RP, Section 14 comes in the picture. Now, prior to your appointment, the SARFAESI had already taken place. You went there, bank has a possession, bank has a seal, and they have stated that nobody can enter it. What happens? You have a right because IBC overrides SARFAESI. Notwithstanding anything contained in the other act, Section 238 of the IBC code is very clear. This Encore Asset Reconstruction versus Varu Sandeep Desai, the case NCLET has clearly decided that even if the SARFAESI took place, bank has taken a possession of the assets of the CD, the RP has a right to take over the possession back and start the CIRP procedure. So if the bank does not give the possession, you have a right to immediately go to, then you just go take the photographs, tell the securities, this is if they do not allow. If the banks do not cooperate, you immediately go to the adjudicating authority and ask for the purpose of taking over the possession of the CD, because IBC is a time-bound act within which you are supposed to do so. Unless and until you immediately act for it, you will not be able to do the needful. So this is the most important part that you need to understand. Even in case of a SARFAESI, the assets are lying with the bank. I repeat the word. Till the time the assets are lying with the bank, the RP has a right to take over. But if the assets are sold by the bank, then it is not a forming part of the CD's assets. And if it is not forming part of the CD's assets in that maturity, that will not be forming part of the corporate debtor's assets. Understand this point. So unless and until the assets are sold, if the assets are not sold, yes, you have a right to go and take over the position. But if the assets are sold, money has been taken over by the secure creditors, then you cannot. So this is the most important part. Thirdly, what is an important for you to do whenever you just go for the purpose of, now it is settled principle, you have a right to go and take over the asset, but if you do not get that, go to the adjudicating authority and get the possession. If that is done, assuming that possession, in spite of that, they are not giving, thereafter, once you get the possession for that particular days, you can ask for the exclusion from the adjudicating authority. So if you are supposed to complete the generally within 180 days or extended 90 days, so 270 days, but these days, say 20 days or 30 days goes for the purpose of taking of the possession, you can go to the adjudicating authority and request for the purpose of exclusion of those days. And when those days are excluded, you have a right that at that point of time, you can consider that as a part of your number of days increase from 180 plus 30 days or 1 plus 270 plus 30 days. So there you won't have any problem. Second aspect is that at a point of time, before the adjudicating authority has given a decision for taking the corporate debtor as a CIRP, the promoters might have given a proposal for one-time settlement to the financial creditors, secured financial creditors. And secured financial creditors have also stated to the promoters to keep some money in the no-lien account. As of now, the OTS is not sanctioned. Companies moratorium started. So when the company's moratorium started, at that point of time, the money does not become of the secure creditors. That is the part of the corporate debtors' assets. And therefore, that money should come back. This is the decision, which is an unreported decision, but Bank of India versus Vinod Kumar P. Ambawat, NCLAT New Delhi has clearly mentioned that this money is forming part of this corporate debtor and not of the bank. Bank cannot ask that this money they already offered us and kept in no lien account. Yes, there is no lien. And when there is no lien, company has gone for the IBC, immediately the money should form part of the series assets and you have a right to take over back the money. So these are the finer point, but more important because you need to understand that where the assets of the company are lying and how to go about it. If the bank is objecting, you have a right to go to the AA or a NCLAT and ask for the purpose of receiving back the assets of the company. Similarly, what happens? At a point of time, what happens? The promoters are also trying to play very smart. What they do is that the day on which they feel that now the company will go to the CIRP and they feel that the order is reserved. So by the time the order is reserved, their lawyer will say that there are very bleak chances that we'll win in this case because the date is acknowledged, everything is clear. IRP will be then appointed in no time, the day on which the order is pronounced, and you're out. And when you're out, what is the situation? Then that they try to just find out loopholes. Let us try to lease the assets of the. So we say that ABC company is going in CIRP. They have their cousin, brother, or friend's company XYZ. They try to lease the entire property to XYZ, and XYZ start working in that particular company. Now, these lease arrangement has taken place only by the directors and not by the because you know that as per the Companies Act is concerned, for the purpose of leasing the assets of the company, you need to have a special resolution. If the special resolution is not passed and the company's assets are leased by the promoters, then this arrangement is considered to be null and void. This also Chennai NCLT has clearly decided in case of CKPL Steels Private Limited, Ashok Magnetics Limited, that you have no right to consider this as a lease, because for the purpose of lease assets, you need to have a special resolution which is required to be passed in the extraordinary or general meeting of the members of the company, and that resolution is required to be filed with the ROC. So if the proper procedures have not taken place, you are right to go to the adjudicating authority or a enclave and request them to take over back this lease property, because this is a transaction which is not backed by the proper legal formalities taken place, and therefore it's null and void transaction and required to take back. So one plant is done like that, also you have to go, because that may be a milking plant. They do like this and say that this lease is given for 10 years, 20 years, 30 years. Now, these 10 years, 20 years, 30 years lease, nobody's there for that much time. And therefore, this lease cannot be cancelled. They enter into such kind of the arrangement, which is, though it looks which is sham, you may just go for the PUFE transaction, that's a different matter. But we need to understand first whether any special resolution by the general meeting is passed. Answer is yes, with proper formalities, that may be considered a lease asset. If not, that will be part of the CD's asset. So then in that case, you have to go to the adjudicating authority and get back it. The most important part is related parties. You are required to exclude related party from the committee of creditors. Any related party which is forming part of the committee of creditors for taking over a decision by the COC or for the purpose of voting, they do not have any voting right. They do not have a right to take any decisions for the company because they are required to be excluded. This also decision was clearly taken care of in the case of Phoenix ARC versus Spade Financial Services Limited. So not a single person from the related parties are entitled to be a part of the COC meeting for voting or giving their opinion on a specific decision. So be careful in this case. Nobody is entitled, and when nobody is entitled, it is our duty to see to it that they should be excluded from the voting right of the COC. They may allow to remain present, but do not have a right to speak or give a votes. If they give a votes, that votes will be null and void. So you have to be very careful and clear in that eventually. So related parties are not to be a part of the COC meeting for the purpose of voting or giving their opinion. So this is also an important for you, because as a member of the, as a RP, who can be a member of COC, you should know very well. I'm not dealing with the various forms required to be filed or various progress reports required to be filed during the course of the COC or various meetings, minutes are to be filed. I'm not talking to you, because I know that for that you are well aware about what are the forms required to be filed from time to time with the IBBI, or whatever that progress report or the reports that you are supposed to give it to the adjudicating authority from time to time. I'm not discussing that. I'm discussing the complexity, the problems that you are facing as IP, or RP or a IRP. So that's more important. At a point of time, what happens? SEBI has attached the accounts because of the fact that there may be certain transactions which have been taken place, which should not have been taken place by the erstwhile management, and therefore SEBI has given a blanket attachment on the CD's account. Now, as I told you that Section 14 moratorium starts, Insolvency and Bankruptcy Code is superseding all other acts in the country. Therefore, the SEBI Act is also superseded. notwithstanding anything contained in either Section 238 is very clear. And when 230 is clear, SEBI's and prior to the CIRP, SEBI has already attached the bank account, stating that no bank account should be taken care of by this CD. If this is blanket bar, now you are appointed as a RP or IRP. Bank accounts are, if you go and open a new account, old accounts are already attached with the banks. Now you go and tell that, okay, fine, I'll go to the new bank and open the account. And I'll say that this account will be operated by me as IRP or RP. What happens at that point of time? The answer says that when the SEBI has given attachment to the bank accounts, the said attachment is also equally applicable to the new account required to be opened. However, in the case of Vijay Kumar J versus Kerala Housing Finance Limited, the Honorable National Company Law Tribunal has clearly mentioned that any bank account attached by the SEBI and the new account is required to be opened or by the CD through IRP or RP, it is this particular attachment will not applicable to the said particular account. So you can go and open a new account. Whatever the attachment takes place, those are the frozen accounts. You cannot do anything. But you can go and open a new bank account on the basis of the Vijay Kumar J versus Kerala Housing Finance Limited. This is the case reported in the NCLT also. So the court is very clear, because you are there for within time bound, you are supposed to complete your assignments. Any attachment took place by the SEBI or any statutory authorities, you have a right, except the PMLA. I'll come to the PMLA later on. But at the same point of time, any other government authorities like income tax or a GST or anybody's blanket attachment is given. Once it comes to the CIRP, their attachments are automatically should have been lifted. If not lifted, if the blanket situation there, you can go to them with a clarity with showing that there is the company has gone to this IBC and I am appointed as a IRP or RP, and therefore kindly lift the attachment or this particular new account to which your attachment will not be valid. Yes, the adjudicating authority has given such kind of wording stating that even if it is attached for the new account that you are opening, it will not be applicable. The attachment will not be.
Sir, can I ask a question here?
Yes, sir.
Okay. I have a situation where company existed before GST period,
Yes.
went into court before GST period, never took GST.
Yes.
Their accounts were attached by SFIO
Yes.
and ED. Okay.
Yes.
Now, case was approved in 2022,
Yes.
admitted in 2022. And this is a case of a real estate company where only class of creditors is only home buyers.
Yes.
There is no other creditor
They are
at all.
abscess. They are basically abscess.
Yeah. So now in this case, their existing accounts are obviously attached.
Yes.
Because of lack of document, no bank is willing to open because they don't have GST. They never had GST when the case started itself. It was lying in, for a long time, it was lying in civil court, high court, and then at some point of time, somebody applied under CIRP and it got admitted. Now,
Correct.
I am completely unable to open any bank account.
The two things that you can do not try to get the original accounts detached, but go for the purpose new account by going to the when you are in CIRP, you go to the adjudicating authorities, take the help of this case, Vijay Kumar J versus Kerala Housing Finance Limited. I mentioned very clearly. There, adjudicating authorities clearly stated that for the new account, whatever that IP or IRP is going to open, this attachment will not be applicable. For the
I know, sir. The challenge is the moment you tell everything about company, which you have to a new banker,
yep.
they are not really willing to. Uh,
But do not say that. See, you say that you please give in writing that will not be able to read it. And then go to the double A. Because of this, it is the case. The double A will direct that. Because what is happening without education authorities, you cannot do this. You have to go to the education authority, states that this is the problem. I'm unable to open the account, and because of that, my CRP is in limbo. Therefore, two things they will do it. A, for the new account, they will allow you, and B, they will also state that whatever the period that is lapsed because of this situation should be treated as an exclusion period for the purpose of CRP also. So you need to take the help of legal person who can draft properly. With this particular case, this case is very much reported also. If it's not reported, I will give also to you. The Vijay
okay.
Kumar J versus Kerala Housing Finance Limited is clearly stating that in such situation, the new account on which neither SEBI nor any kind of the what you say that the other statutory authorities have a right over the new account where IRP or RP is appointed.
No, they are not coming and taking the right. The challenge is bank itself is not really comfortable,
Willing.
and I have
You
not
say
really
that
gone
they
to
are not
a.
willing to take up the account because
Yeah.
of the specific image of the company or because of that.
Yes.
Should
Yes.
I
Yes. Yes.
go in such? In that case, that's what I'm trying to tell you that you wherever you want to that take a proper direction from the executive authority. Once the
Okay.
double A will give a direction, say for example, you have gone to the State Bank of India X branch. Just give an example, or a
Yeah.
Union Bank of India X branch. There, the bank will say that okay, sorry, we are not interested. That tell them to give in writing. Once they give in writing, you just go and get the direction. So automatically the direction will applicable to that particular branch. That's what I'm trying to tell you.
Okay. So can court mandate bank to open an account, or is it bank's
Yes.
discretion?
So, see, basically, the ultimate IBC code is very much there for either for the resolution. If resolution is not feasible, then liquidation. Correct? So this is the
Yeah.
hindrance. The hindrance for you. So you need to go to education authority, state that this is the problem. I have gone to that, but then get a things in writing stating that they are not opening or because of these problems, we are not able to open this. Get there from later. Then the double A will write that this account is open and there is no attachment applicable in this case. That double A will give the such kind of a situation. If they will not be able to give, you can go to the NCLED also and they will give also. But NCLT will give on the basis of this particular judgment also.
Okay, sir. Thank you.
Thank you for this. Let's go to the next. Now, what happens that the certain assets of the CD are being attached for non-payment of municipal taxes. What happens? Like recently the SR has said the GST, say for example, you're not paid and the attachment are required to be lifted. They have no right to continue with the attachment. Even in one of the case, what has happened recently, I have found out that because of the labor's payment have not been taken care of, the labor's law, the authorities have gone to the collector and state that these assets are required to be attached. So it was attached, and thereafter the company went to the the CIRP. There also, they have clearly mentioned that you are supposed to give, though there may be some legal battle that may take place. However, you are supposed to get the attachment vacated, let these municipal taxes, assuming that they are basically operational creditors, they will be falling as per section 53. But as of now, when CRP started, that attachment has to be lifted by them. So this is the basic situation we need to understand. Except in case of the asset attached in the PMLA 2002. In PMLA Act, because what is the court's view, here they say that the money with which these assets have been taken place, whether it is a fraudulently taken or there is a money laundering, and whether these money are being of the asset corporate debtor or not is not known. Until the time the entire situation is not completed, you cannot afford to say that these assets are totally free, and therefore in PMLA Act under 2002, they do not allow till the time it is clearly mentioned that this attach is out of the without, I mean, these are of only corporate data and there is no money laundering take place. If such situation takes place, then only it becomes a series asset. Otherwise, those assets are required to be kept as it is till the time the PMLA is not giving clean sheet to the CD. So this kind of the situation has taken place since long.
Sorry, sir.
There,
This is
I
PMLA.
would, sorry,
PMLA is also applicable to new account, or
I'm coming to that, sir. I'm explaining that aspect. Give me 2 minutes also. What happens that the IBC is as of now evolving. It has still not made a lot of clarity in a lot of aspects because of the fact that everything is not mentioned everywhere. And therefore, unless and until the proper case laws are taking place, you cannot afford to get the clarity from that. So in this eventually, as I said, that SEBI attachment or a GST attachment took place, you can just go to the court and get the judgment. In PMLA, what happens? If the new assets are not out of, if you one can establish that these assets are not the money laundered assets, and they are basically of the corporate debtor assets, assuming that somebody has sold the goods, I mean the CD had sold the goods of rupees 10 lakhs to X, other asset might be money laundered, but this 10 lakhs rupees has come right now today to me by a demand draft or a check or in a bank account, but bank account is frozen by PMLA, then I will say that this money is basically not out of this is out of the CDs asset, and therefore this should not be forming part. But then I have to establish that with the promoters that yes, these assets are not under PMLA 2000. Now, if you have any question in this, you have a right to ask the question. Should I go further, sir? Okay. Now, what are the other challenges that we are facing as of now is during the course of the CIRPs? We will take break at about 4:15 for 10 minutes for a small tea coffee break, and then again we'll come. So still for 4:15 minutes we'll go, and thereafter we come back. Right now I'm going further. Now, what are the other challenges that the people are just facing? It is your duty as IP that yes, you should keep the company's assets intact, going concern, and the value of the asset should not deteriorate due to your lapse. See, generalized, if it is happening, we cannot do anything. But because of the certain enact or act of the IP or IRP or IRP, in that eventuality, it is me and you who are responsible, assuming that listing fees are required to be paid. Up till now, it is done and you have not paid the listing fees. It is delisted. It is your duty to see to your listing fee has to be paid. You have to go to the COC because see, today, if you look at the listing as a cost, yesterday I was reading that in the Economic Times, they have given a one calculation today or yesterday, they have given one calculation that what is the cost of the raising of the funds, the lawyer's cost, the merchant banker's cost. If the issue is lower amount, 165 crore or 200 crore or something like that, then it goes up to as 25%. Another, if it is 10,000 crore or something, it may be as less as 2%. But that 2% is too good for a company. So this delisting, the listed company has its own value. We know very well. So wherever the compliance are required, it is our duty to comply all the formalities for the listing also. And the listing should continue till the time you just go for the resolution of that particular, because listing has a value, maybe 5 crore, 10 crore, 50 crore, as the case may be. So this listing, you should continue and you should not see to it that because of our lapse, this listing should have any problem. It is our duty to safeguard the assets, as I told you. Even we have a, say for example, the intellectual properties. So intellectual properties also, assuming trademarks or it has the copyrights or anything, you are required to pay renewal fees. You have to see to that as RP or IRP, you have to pay that money and do not try to just stop it, because that money, if you do not pay, ultimately copyrights or trademarks will go out and you will be in trouble. So I request you not see to it that because of our lapse as RP or IRP, nothing should happen to the company. Most important part is the transparency, integrity, and competency. What happens at transparency? When we talk about transparency, see, things as of now, there is a slightly, I would like to say that there's a small distrust between the promoters and the IRP is or RP is that promoters always feel like that the RP is my boss and he tries to behave as if whatever he feels. I request all my friends and colleagues requesting that this kind of the false impression should not go to the promoters. We are not here to make money. We are here as an officer of the court and we have to see to it that ultimately there has to be no distrust in you, neither by the COC, nor by the executing authority, nor by the promoters, suspended directors. It was their hard-earned money. I am not here to make money only. I am being paid for my fees. That's all. I'm not interested to take any amount more than my fees. I am interested to see to it that the maximum number of the cases, I should see to it that it should be resolved. So my ultimate intention is the resolution of the cases and not the liquidation of the cases. Number one. Number two, I have to see to it that minimizing of the cost and try and see to it that that company should earn. See, you are like a CEO of the company. You might be paid 5 lakhs a month or 10 lakhs a month, including your team and everyone. So when you are doing 2 assignments, I'm sure that you are getting enough money. You should see to it that the distrust should not be there. You have to ensure the compliance with the IBC. All records, whether it's with AA, with IBBI, or with COC. Any person or with the, like I said, that with listing of the company, listed companies are there, or ROC records, anywhere per se, or even the assuming that there is going to be the subsidiary companies, foreign subsidiaries are there, then you have to do RBI also. So everywhere you have to see to it that all compliances are required to be taken care of. You may hire other professionals, take their help if you have any kind of a problems, but do not see to it that you are just not complying any kind of the situation. If you're not complying, the assets of the city will be deteriorated. You are directly blamed for that. So my humble request to all of you is that your records, all compliance is to be made everywhere, along with the complete documents you have to keep. I'm sure that everyone knows that 7 years you have to keep all kind of documents, what that you've done. Wherever required, make a proper videography, keep a digital data properly, keep a physical data properly where required, but do not try and see to it that those data I should have any kind of the problems, because you have to keep for the next 5-7 years till the time the entire section complete and you are out of that. So those things are more important for you. As a IRP or a RP, the important part is the compliance. You require, if require, you have more than 1 or 2 CIRP, IBC work, then I request you to have a 1 person specifically for compliance. Let him comply everything for the company as well as for yourself. And if you are a member of IPE, try and mention, see to it that IPE should also, 1 person should be there who can start making compliance for you on your behalf, so that what happens, nothing should remain. You should have a proper complete chart stating that what compliance are required for the CD, what compliance are required for yourself, what compliance are required to be given before the to the court also. So everything means to educating authority. So everything should have you should have a proper listing of it, making the compliances, and then write down that when you complied with, and accordingly keep all the records with you. So records are more important for you, because ultimately, if you can win your any cases of the IBC before the IBBI or before any third party, only by keeping the records with you. So this is the most important part that you need to understand. I do not doubt that there is any integrity doubt, but even if our future generation as IP, nobody will put a finger against us that yes, you guys have made things us bad. That should not happen. So integrity is more important. And I do not doubt the competency unless you are competent to do that. If you're not competent, try and become a member of any IP. There the other competent people are there. Along with them, you try and work out a solution. You may be a responsible person, but if you have doubt about competency, have the service of somebody who can back you properly, and you can keep proper records, proper details. You can guide you also, student gradually. It is nothing but a kind of the sharing the fees, but at the same point of time, you will not find yourself in a trouble. So this is the most important part that you need to do. Like, say, for example, real estate projects are the RERA compliances. You do always look into that. Whenever once you are appointed, please give everyone a letters along with the AA authorities order saying that you are appointed and the company is now under CIRP. Moratorium started. So I am not at a blame. Every time, whenever it is required, you have to always see to it that proper compliance is to be done. Similarly, for the purpose of because we are dealing with the corporate insolvency resolution, there are GST issues, there are income tax issues, there are PF issues. We as an IP should see to it that our department, particularly the company, should also do, and that should be check and mat, because there has to be a good lawyer, either their lawyers or advocates or their legal person or their chartered accountants who does their work of GST or a income tax or a TDS or a PF, because you are now in charge of the company. So something happens, you will be blamed. I do not want any of my fellow members should have any problem. So you need to see to it that all compliances are to be made in time. And for that, if you require any persons to be hired from outside as a consultant or anything, to whom you are having a proper confidence, your internal company does, and accordingly get it checked by somebody, so that there should not be. So you may be having some compliance persons who does every checking on a monthly basis, so that it will not create a complications. So you will not be in trouble. The other aspects that we need to understand is the ensuring and maximization of value of assets. It's the value of assets, so maximization is the most important aspects. Ultimately, IBC's ultimate purpose is what? They want that the value discovery. Even if you look at public issue, also what they do is why they are going for a public issue. It is only because of that they want to discover their value. Whether say today I feel that my company's value is 1,000 crore worth, but if I go to the public and I feel that yes, my multiple is not 10, but my multiple is 17 or 20. So my company is 20 crore, 2,000 crore worth. So therefore I am going and getting listed. Similar situation comes in the IBC. It is you and me who will have to see to it that the value should be maximized of the company. Ultimately, any COC or any member of the bank will give you the work, provided if you have maximized their value in past or present or future. Unless that object is achieved by the COC, unless that object is achieved by the anybody, then you will not, otherwise you will not get more work from there. So if you want to continue as an insolvency professional, remain in this game, only thing, three things happens in, as I mentioned at the second: transparency, integrity, competency, and value maximization. See to it that whatever the base that you can get, please try and work out. Nowadays, a lot of portals have started coming up where they try to just match up with that. Okay, fine, they put up those assets in their website, and then there are a lot of people who are interested. So please see to it that maximum number of people sees your advertisement, maximum number, like what we are doing for social media, like these professionals are doing, other professionals, not the chartered accountants company I'm talking, but say for example, he tries to say, or other businessman, he tries to see to it that maximum advertisement takes place, and ultimately people will come and see that, and they give the maximum value. Same situation comes here. That either you are a real estate company or you are a pharma companies, then you have to see to it that value maximization of the asset is the ultimate aspects. So value discovery, and thereafter you try to maximize that. So even if you just give the work to the any person who is a valuer, you have to also look into that. That valuer also should have a clean image. They are having a proper training and they have a proper experience, so that they give a proper judgment of the value of these assets, and then only you will try to just maximize it. Otherwise, it's not possible for you to maximize it. Yes, in that case, If the COC decides something differently, that okay, fine, 5%, 10% discount they want, then the value that is put up, that's a different matter. But we as IP should see to it that everything should be put up before the COC to look into the aspect that there should not be any problem. Now, coming about the PUFE transactions, preferentials, undervalued, fraudulent, or extraordinaries. Now, see, before we go for these aspects, we need to understand that what is the act that it says. Act along with the rules are required to be looked into. Rules are very clear and they are stating that as a RP or IRP, they have mentioned very clearly within so much days you have to find out that what are this. Within so much days, once you have to make an opinion. You as RP has to make an opinion. It is not that the opinion is to be what I've seen that in number of cases, they are giving to the transaction auditor to form an opinion. Please look into these proper section and rules where it is clearly mentioned that RP is required to form an opinion. Why the section 43, 45, 50 or 66 applications are not being taken properly by the NCLT or by the RP is not winning such kind of the cases only because the fact that they are not reading the sections properly and they are not making the application properly. The first and foremost thing is that you as RP will have to form an opinion that yes, it's a preferential transaction, undervalued transaction, though it may be with the help of somebody, but ultimately it is you who have to form an opinion. Normally, what the people are doing, the task that they are giving it to the transaction auditor to form an opinion. Then never you will win because the other lawyer will definitely states that it is required to be formed by RP, which is not done, and therefore this is not the entire application is null and void, required to be rejected. So be careful on that. When you make an application, then you have to say that I have formed an opinion that this is a preferential transaction or undervalued transaction. Then you can say that what are the bases on which you have formed an opinion. You just give the complete details on that, on which you are relying upon. In one of the application, I have found out that the transaction auditor has formed an opinion, and then he stated that I have relied upon the following things. Number one, discussion with the promoters. Number two, he says that from social media information. See, these are not the way. You are transaction auditor. The transaction auditor has to audit each and every transaction and then give his judgment or then give his opinion. From that opinion, RP will form an opinion. Unfortunately, here the basis of the forming an opinion is also required to be taken properly because that is viewed seriously by their AA. You have failed in doing your duty if you are not formed an opinion. You have failed in your duty if you are not audited the transaction as a transaction auditor. So what happens? And you have failed in your duty that every transaction is required to be audited and then come back with you. See, you cannot say that on a social media and on a discussions or anything. You've not seen the books of accounts. You've not seen the relevant evidences, not seen the relevant records. You've not made a judgment. You've not made an effort to see to it. Thus, you are just talking about generally. That is not enough. What is important for you to decide on a PUFE transaction is that these transactions, whenever you are coming out that you should, first of all, you should have a clarity, this is a preferential or undervalued or a fraudulent or a extortions. For 43, 45 and 50, you can have one application. For a 66, separate application required to make. That I'm not going in the actual sections and all because you know better than me also. You are dealing with every day on that. So you need to just divide this both the application in two different parts. One is 66 application and second is a 43, 45, 50 application. Number two, as a RP or IRP, your duty is to form an opinion on the basis of 1, 2, 3, 4. Do not rely only on transaction audit. Whatever that transaction auditor has done, you do three aspects. First of all, look into the audit. Ask the promoters, what are your comments? and then also go in depth of the transaction. And then decide about what is the actual situation, what the transaction auditor says is correct, or what promoters has given the explanations, and from that you are satisfied or not satisfied, make your comments on that. And accordingly, then when you are making an application, you actually mention very clearly that why this is a PUFE transaction. There, you say 66 transactions are fraudulent because this is defrauding the creditors. Certain people I have seen that the same transaction they are mentioning as preferential and same transaction they are saying fraudulent transaction. Please do not make a mistake. You need to understand these are the two different transactions. So either it's a preferential or it's a fraudulent or it's a undervalued or it's a extraordinary, but it cannot be in both the ways. They are supposed to be a different transaction. So please do not try to take into both the applications, because either you are unable to understand that, then take the help of somebody and work out a solution. Ask the legal luminaries that whether it's a fraudulent, or ask the other chartered accountants, fellow chartered accountants, big four persons who understand this, those who have done a forensic audit properly, who understand this. Then only you decide. Please do not blame anybody, particularly see this view of a transaction where the promoters are basically not comfortable. Till the time you have filed the PUFA applications, they were cooperating. After that, they may not cooperate, because they always feel like that today you are against me, and therefore why should I decide about this? So here you have to be very careful when you are deciding about the PUFA transactions. You have to be clear about this, that I want to be I do not want to unnecessarily create a complication for the purpose of just giving it. I will go in depth of that. Say, assuming that somebody has written off the debtors, 5 crores. For 3 years, he had not written off anything. 5 crores is written off in a specific year. Now, this company was an agriculture company. And there I say that particular year is the year of either the heavy rain or a sukha, means there was no rain. Farmers were unable to make the payment. Government has also given a proper help to the farmers. Lot of things have taken place. So you have to also look into that also, that whether there is the drought situation took place, or whether there is a heavy rain took place. What is the government stand? How many of these same industries have passed through a rough weather during this particular time? If there is anything which is not understood by us, please take the help of somebody and then find out that. Because see, promoters must be knowing that what he has done, he knows very well. If he feels that he has not done anything wrong, he will definitely go against you and start giving non-cooperation. I into that, we have to take proper cooperation from the promoters, and we do not want unnecessarily erasing, but at the same time, if he has done a malafide with the intention, you have to go for a fraudulent transaction. So this is what we have to decide, put up before the COC, pass a resolution for the purpose of this. Again, now in certain resolution plan, they say that the entire PUFE transactions, any amount will receive, that will be a part of the resolution application. This has to be also ratified by the COC. COC agrees to that, COC may not agree, because COC says that these are my money, from which the promoters have done siphoning of the money or whatever. So this should come to me and not to the prospective resolution applicant. So you have to be very clear right from the first day that whether the PUFE transactions, whether it is to be taken care of by the COC. If yes, generally yes, then if you cease to become a RP, assuming that the plan is approved, thereafter immediately you have to also make a request to the COC members to change the application immediately and let the COC member to continue instead of the RP. Now I believe that we are at 4:25. We'll have a 15 minutes break. At 4:40, we'll again meanwhile there is a break for a tea coffee. Thank you so much to everyone. Thank you for patience hearing. We'll take up this. Very good afternoon. Should I start?
Yes, sir. Good afternoon.
Thank you, sir. So we were discussing about the PUEF transaction or PUFE transactions. As regards these transactions are concerned, what is happening and what I have seen also that, first of all, either the insolvency professional, insolvency resolution professional or a RP is unable to actually draft the application properly. They do not give the adequate evidences. Unfortunately, the legal luminaries, they are not acquainted with the accountancy and the accounting standards properly. And accordingly, what happens? The applications drafted by the RP or the lawyers of the RP, wherein the other parties legal expert with the accounting background may try to find out certain loopholes and just he tries to get out of the situation. So in my view, what one has to understand and look into that, whenever we have found out as a RP, it is our duty to first of all form an opinion that whether it is a preferential, undervalued or a fraudulent or it is the extraneous transactions. So even if somebody has formed the opinion, we have to just look into that and try and forming another opinion, mentioning the same thing clearly in our application that as RP, I have formed an opinion. And accordingly, I am making an application. Secondly, there is a timeline which is given in the Act for forming an opinion, for appointing a transaction auditor, then also making an application. The Honorable NCLAT has clearly mentioned in so many judgments that timelines are not sacrosanct and on the basis of which nobody can circumvent this. There they are very clear about that. Timelines are for it is not sacrosanct, meaning thereby if some days are here and there, yes, you have a right to give an application and that application can be sustained. It cannot be only because of the fact that within a specific timeline, if you're not made an application, it is just not sustained. That is not the case. So there it is very clear. The timelines are not the mandatory, but directive for us. So that's what we need to understand. However, having said this, the most important part is to decide about the preferential or undervalued or fraudulent or extraneous transaction. As I told you prior to the break that the people are trying to work out preferentials and fraudulent together. Same transactions cannot classify into the both the aspects. However, if you want to classify, then say, for example, this is a 10 crore rupees loss to the company, then you decide that 2 crore is a preferential and 8 crore is a fraudulent. So mention very clearly. Do not try to say that entire 10 crore is a preferential as well entire 10 crore is the same transaction is under, it is a fraudulent. That you cannot do it. Otherwise, the person will take the advantage of the situation and say that as the RP is not clear, he is unable to make the form an opinion, and therefore this application is required to be rejected. So, in my humble submission, when we are trying to find out any transactions which are having a bearing on the corporate data, and it is for defrauding the creditors or some preferences given to somebody and from whom we have to recover the money, in that eventuality, you as a RP or IRP or a liquidator will have a role to play and see to it that nothing should at any point of time take place against you. First of all. So nobody can pinpoint that you have made a mistake and therefore I am at a loss. COC may not say, RA should not say, or promoter should also not say that she should not go scratch free, stating that this is a totally wrong application. That should not happen. So these are the things. By drafting the application, we as the RP will have to be very clear, forming an opinion. Every detail, my only humble request to it, even if there is a delay, why the delay took place, please mention in your application, so that somebody will not get the excuse that there's a delay. Somebody should not feel like that he's trying to, that he has not adhered to the act in a toto, and therefore this application is rejected. So certain flimsy ground, the application should not get rejected. This is what my only humble request to you. So you have to be clear and careful on that. B, whenever say we should have a proper knowledge, because we all are qualified insolvency professionals having a proper knowledge of accountancy. And when we have a proper knowledge of accountancy, we understand that from where the promoters have a defense in this, or where the promoter does not have a defense. So my only humble submission to everyone is that at least try and find out the situation. If you are confirmed and clear that it's a fraudulent transaction or a preferential transaction or extraordinary transaction, please have proper evidences of the same also. Assuming that somebody has sold one property, immoral property, to the promoter has sold to his relative at 10 crore rupees. And at the same time, this 10 crore rupees consisting of, say, for example, 5,000 square yard land, or 5,000 square meter land. So you can find out that it's 20,000 rupees square meter. That is the price of whatever the X price is there. Now you just go and find out that what others, the similar nearer area, if the situation is such that the similar transactions took place where 30,000 or 40,000 took place, you have to find out and give an evidences. Once you give the evidences, then you can say that, let him defense that no, this land was not of the similar situation, or whatever he wants to say, let him say. But in that image, it is your duty to see to it, your evidences are adequate enough to see to it that whatever you believe is true and correct, and therefore the promoters have or he has to make a lot of efforts to get out of this. If it is fraudulent, he wants to get out of it. So my request to you is that when we are making an application, our all documents should be perfect. Wherever there's a perfection is not there, where is a delay or something, mention the reasons for delay. Thirdly, keep all the evidences with you. May not be giving at the same time. Fourthly, before making an application, always give a chance to the promoter to respond and reply, and take up their also response while drafting the application, that whatever the response that they say is acceptable or not acceptable for the reasons based what are there. So it is our duty to see to it that whether these are acceptable or not acceptable. So while any application which we as a IP decides to make, not only for the purpose of making it, but it has to have a proper result at the end of the day. So either the COC or RA or a successful bidder, he should get proper money out of your application. Then only it is justified. Otherwise, every efforts made by you may not go in a right fashion. So my only humble request to you is, whenever we are making such kind of the applications, at that point of time, it is our duty to see to it that all the preferential transactions or undervalued transactions or fraudulent transactions applications are properly supported by first of all, give a chance to other party to respond or reply before making an application, take up their views, incorporate in your application. Why it is not properly decide, give the evidences. Also, the accounting standard and your knowledge with respect to the accountancy is required to be taken into account, and then only take up the situation at the next level. So in my view, when we do some application as RP or IRP, our application has to come to a logical end, and wherein either the promoter justifies that, or At the same time, the promoter will have to make the payment towards the PUFE transaction. Otherwise, these transactions will go fat and nothing happens in this subject. So my only request to you, this is the most important part. We need to read every word of the act along with the rules made therein. We should have a clarity on the accounting standards, and my lawyer or my draftsman should be such that whatever I understand and agree and that has to be forming part of my application. If that happens, then only the logical conclusion, logical situation takes place. Now, what happens? The next aspect is the valuation of CD, identifying hidden assets synergies. What is this valuation of CD by identifying hidden assets? When I'm telling you about the hidden assets, at a point of time, what happens? The CD is having a lot of other assets which are not there on the paper. Nowadays, I am very happy that IBBI has come out with a new circular wherein they have mentioned clearly that in IAM, you are also required to mention that what is the carried forward losses. Carried forward losses is a contingent asset as of now. However, one of the resolution plan I have seen that very drafted, I am talking about before 2 years, very nicely drafted, stating that against all the dues of the income tax, I am paying rupees 5 lakhs. And accordingly, the resolution applicant has mentioned. Accordingly, all the dues are considered to be complied with and nothing is required to be payable until the time, the day on which I, as RA, takes the assets of the company and become the owner of the company, no further formalities to be taken care of. However, any TDS or any amount which I am supposed to, the CD is required to take up, the said money should come to me. What has happened that this is an infrastructure company. So every time when they are making some kind of infrastructure, there 1% or 2% TDS was deducted, as the case may be. So up to say, for example, 2015, they were they were showing a good profit, and there was 25 crore rupees demand was there. Thereafter, from say 2016 onwards, they become a loss-making company, but every year, what 2 crore, 3 crore rupees, the TDS was deducted. They could not recover because there were losses, and therefore, ultimately, 12-15 crore rupees, the amount was recoverable. Now, he has stated that against 25 crore plus taxi, plus the interest till date, I am paying 5 lakhs. So he's out. And then he has a TDS of rupees, say, for example, 12 crores to be taken. The department had not adjusted this TDS against the demand. So as of now, it was pending as it is. So he says that from 2016 to 2000, say, for example, 20, I am supposed to the company, the CD was required to take 12 crore rupees as TDS plus interest till date, meaning thereby he was supposed to take 16 crore rupees from the department. So he pays 5 crores, taking 16 crores from the department. Now, these are hidden assets. One has to understand that the hidden assets of the, and when you are doing, you are giving for valuation, you have to also tell the financial creditors, please look into that. If the RA is giving such kind of a plan where income tax has not adjusted the demand, earlier demand against the TDS, thereafter deducted, then this has to be considered as a part of the assets of the CD, and accordingly the resolution. Otherwise, what happens? Say, for example, he has given a resolution plan having a liquidation value of say 40 crore rupees. He has given a 42 crores plan. But now he's getting 16 crore additional from the income tax department by paying 5 lakhs rupees. What happens? If you look into that 40 crore plus 16 crore, the actual valuation of the asset is 56 crores, against which he is giving 42 crores. No COC could understood this. He has got this additional money without going into that. So these are hidden assets. So as a RP or IRP, me and you should be agile to understand that these are the hidden assets which should come to, which should be properly put up in your IM, so that with only one RA cannot get the benefit of that. The all others who are in the competition should understand that these assets are there. Some credit for losses are there. Say, for example, 500 crore losses are there. While you are RA, you are getting that 500 crore rupees losses to be set off against you. I'm talking about the pre-year of 28-4. In that eventuality, this 500 crore rupees having a say 25%, even the tax to be paid, it works out to 125 crore. So this is the hidden asset. So nowadays, IBBA has mentioned clearly that whatever the credit for losses, please mention very clear. So these aspects cannot be forgotten. GST credits are lying, you have to mention. MAT credits are lying, you have to mention. Again, when valuation is required to be taken care of, synergies are also to be taken care of. Because what is a synergy? If I, as a CD, has also put up money in my subsidiary company, what happens? Subsidiary company's valuation, say 20% stake, 50% stake, 100% stake, whatever that, whenever the valuation of subsidiary is taking place, that should be forming part of my assets, the net value of the subsidiary. So we have taken into account this subsidiary, this company is gone, the other company is bound to go on. That's not the case. Take an example of NACL. NACL was also holding shares of the other company, which is now doing fantastically well. NACL has gone to docs, but the subsidiary is doing good. They are now giving the plan. So what my basic request to you is that we have to understand that what is the synergy between these two companies, and accordingly we have to work out that valuation of the CD. Without that, it is not possible for us to do that. So this is another aspect. We have to also understand that cooperation from other authorities like bank, police, PSUs, etc. See what is happening at a point of time. Once you are in the CD is into the CIRP, we are not getting a cooperation from banks where there is no limit also. Bank says that now what is this? We are not. You have to go and explain that this CIRP, you are not worried. We are there to see to it, but you have to give a cooperation. Wherever you require a police protection or police cooperation, please go to AA, adjudicating authority, take the order from them, go to the police station and take their help and do the needful, because they have power to do that. They cannot say no to it. And once their power is there, police also cannot. So if you just give it to the concerned police inspector or whosoever they in charge, he has to give a police protection to you. Any kind of a PSU, say for example, some people are having a problem with their electricity. Then this electricity, they have decided to just not to restore. If you make the payment of the normal regular payment for the purpose of your normal operations, you pay them and your operations will continue, because this is nothing but required for the purpose of operation. So all PSUs will give a proper cooperation. So you have to take the help of them, see to it that the company should remain in a going concern basis. The most important part, what is our leaky as IP or RP or IR? We try to take everything for granted, assuming that I as the RP has incurred the expenditure and my fees are there. I forgot to ratify through a COC. What is happening? At a point of in one of the case, what has happened that he has said that my total expense is 110 lakhs rupees. He had ratified only 50 lakhs from the COC. Now RS says that I am supposed to pay 50 lakhs. He says that now you have to give 110 lakhs. COC said that we have ratified 50 lakhs rupees. The ultimate resolution plan went for that. He says I want 110 lakhs, 60 lakhs rupees additional. Then AA will say that okay, fine, give a secure deposit or I give a bank guarantee. So this dispute should not come. It is my and your duty to get the ratification of all the expenses by COC members. Our fees also required to be ratified by COC. People are making a biggest mistake of not ratifying, and thereafter you have to go on your money to the adjudicating authority and defend yourself. This is again an additional cost, because you are from, say for example, X place, NCLT at Y place. At a point of time, you may not go every time. You have another assignments, and this kind of the situation comes, and ultimately you do not have money to appoint a new lawyer, and then you may be losing the case also. So my humble request to you, you to see to it that you to ratify all the expenses by the COC. Proper resolution for ratification is required to be given in your minutes, and it has to be put up along with the minutes. So please do not make that mistake. Next is compliance for IM, inclusion of all material event information. If you do not take this, during the course of IM, so what has happened that we have to be more cautious about preparation of the information memorandum. If we do not do that, or if we make a loosely word, or we take somebody's standard to put up in our company, there are chances that the people will try to find out the defects from that, and then you may have to go and face the legal consequences. I only humble request to you is always go through the information memorandum 3 times before you just put up to your website or anywhere. See to it that everything has to be of your company only. Nothing of the cut and paste should be there, because of the fact that I have understood that in some of the IPs are doing only cut paste practice, which I request you to see to it that it should not be. See, in some cases, the same information you may try to put up that, but always after putting up that also, you to go thoroughly through it so that it should not look like that some other company's information is also here. So that is more important. Or in other company, it was decided that we will take a earnest money deposit of 5%, assuming that of the bid amount, or minimum 5 lakhs rupees or 50 lakhs rupees. Somewhere it is mentioned that in another way it is mentioned 15 lakhs or 50 and 15. So all those things matching should be, each and every aspect should be seen. Otherwise, somebody may go. Only they will say that in Milord in IM, it is not clear, and therefore I paid 15 lakhs. So by my IM should be my bid should be taken up. And then again you go and start going in the legal matter. I request you to avoid that. Every material relevant information, no duplication, no different things in the IM. At one place, X amount and Y amount in another place should not be there. To avoid litigations for us, we to save ourselves. That's the first thing. Then CD, and then others.
Various, sir, can I ask?
Yes, sir.
Yeah, this most of the IM they have the disclaimers in the beginning. So
Yes.
to what extent they are valid or relevant?
Sir, disclaimers can save you to some extent, but not in always. Why I'm telling you? Disclaimer that you say that this is the information we have received from the CD or the promoters and from the books of accounts or others. That's what you are trying. You're not saying, see, I'm only trying to say that in EMD, one place you send 15 lakhs rupees or 5% of this. Somewhere you mentioned that 50 lakhs because of the cut paste. I'm trying to say that particularly here. Disclaimer will save you to generality, because there you are just making the disclaimer of the aspects that as per the information received from the promoters and from the company's documents, I am just giving it. Something which is not there with me, I have not given. Yes, there you can say, because you have taken up the company's control before 30 days or 20 days, and now you are just preparing IAM. Chances are there, and if there is no cooperation from the management, definitely there is not, all the details may not be included properly. Or at a point even the management gives even the proper cooperation, they may have also forgotten certain things. The company has some kind of asset which is not available with them in their, it is mentioned land, 50 lakhs rupees, but 50 lakhs rupees consists of 1 lakh rupee land purchased by for 30 years by the forefather. The person does not know, and therefore that 1 lakh rupee land could not be included. So those disclaimers on the basis of the information received from the company and the documents and details, there you are mentioning, that is always saving you, because of the fact that anything which comes thereafter or which is not revealed to you or which is not understood to you, there you can be safe. But I'm just trying to tell you that wherever you're doing cut-paste things, or wherever you are trying to do, because I have done some pharma companies one work and the second pharma company comes, I'm trying to just take up the same situation here. See, 3 things happens there. what happens every time the law changes, every time the formalities changes. So you need to also see to the formalities also to be taken up that. Number two, like nowadays in IM, you are supposed to give the details about the carried forward losses. Prior to that, you are not supposed to. So you have to be extraordinarily cautious while making it. There you cannot say that I have mentioned that whatever the information, but the promoter will say that I have given this information. Why you not taken into account? That's what I'm trying to say. So this general disclaimer will save you if you do not have information, or if you're not the information which you asked for and not received. But if it is not asked for, which is compulsory to write in IAM, and then you try to say that I have given a disclaimer, therefore I am safe, that is not the case. That's what I'm trying to say. Whatever is defined by the IBBI, whatever is defined by the COC, or COC says that you are supposed to mention this, and out of that, if you do not do that, then you are in trouble. Otherwise, you are not in trouble. I think I have given the answers to you, my friend.
Yeah.
Coming back to the next aspects, what we need to understand is deciding about eligibility of PRS, proper documents, commission, etc. See what is happening. Section 29A is more important for us. We are prospective resolution applicants. It is the duty of the RP or a IRP, whosoever it may be, that he has to decide about that section 29A is applicable. So nowadays, what happens? Number of people are just giving the you one kind of this services that 29A we will get checked and do it. Try and get it done. Mention that we have taken the opinion of Mr. So-and-so on the basis of various aspects, because see, certain things will not be able to, because whether he is defaulted somewhere, we do not. He is not qualified by SEBI, we do not. And I cannot go and check every time. Prospective resolution applicant has what kind of, he is giving upon oath everything. However, it is not only that he gives an oath and therefore we take as it is and then we go ahead. We know that, assuming, just give an example, that we know that Jet Airways is now in this, and everyone knows that, and thereafter the promoter of the Jet Airways comes and he becomes a PRA, we should be overcautious. Though he gives the affidavit, you say that, okay, he has given affidavit, I would rely upon. You cannot rely upon it. You need to do an independent inquiry also. It's not only that whatever he says, it is done. Yesterday, I was just in the NCLT, when honorable members were asking to somebody, there was a personal insolvency, that have you done, I mean, the bank or you have made any kind of the detective agency? You have found out that what is their lifestyle? Have you found out that how many trips that they have made abroad in last 3 years? What is their livelihood? What they are, how their normal style of living? So you try to understand that they are going to such an extent. So when you are in a PIRP, personal insolvency resolution, you are a professional, then you have to go thoroughly through it. You have to see to it that that person, whatever he says that I have only this much money, or I do not have any money, therefore I'm not, I should be declared as insolvent, and I should be out of this. That should not happen. That it is your duty to see to. This is what the court was asking. The honorable court was asking these questions. And then it becomes your duty, and then he says that, okay, fine, go and find out everything and then come back at next time. We give you time of 1.5 months. So my only request to you is that whenever we are doing some kind of the PRS, if we give it to some third party, or if we rely upon the affidavit, is not allowed. Assuming that he must have given us some kind of the resolution plan prior to this, where he has failed to give the money and he become ineligible, but then he directly applies. We do not know. He gives the affidavit. He says that I was not knowing the law. He can say anything. But we as RP should definitely ask that, have you given any prior plan? Yes or no? He say yes, whether that is met by you. All those things we have to, we have to decide about certain. Though we get every kind of the professional services from third party or anywhere, but it is my and your duty to at least make ourselves sure that we are not lacking any kind of the criteria. Even RFRP, getting it approved by COC. It is also a task by itself, in my view. Because request for resolution plan, where you are defining key rules like metrics, EMD, performance guarantee, etc. See what is happening at that point of time. What is the correct EMD? What are the criteria for this bigger company, smaller company? Who are the players? What is the valuation of the company? Or what can be? And who can come here as a PRA? From that, you decide about that EMD. Because ultimately, my only aim is to maximize the value. So if I make the EMD of 50% of the resolution plan, assuming that, then the people will not come much. So ultimately, I am trying to play with that guy. I wanted a 1 or 2% only, and therefore they have come. So that should not happen. My basic question is that I need to decide that the maximum number of RS should come, PRS should come, so that the value maximization can be carved out, and we can find out that we can discover the proper value. We have to look at the PUF transactions who will take benefits. Whether I will benefit, I mean the PRA will benefit of COC. Everything, collateral securities, not belonging to CD, you have to mention everything. That these collateral securities or this is a company's assets, but given for the purpose of the, say for example, to somebody or a subsidiary companies for their money, and is now lying with the so-and-so bank and is not forming part of the series assets. You have to be clear, whatever it is. So you need to decide. Everything has to be crystal clear. Tomorrow, nobody should challenge you as a RP again for preparation of the RFR. Always get it approved by members of the COC. Tomorrow, the blame should not come to me that I have made some mistake. Matrix also should be properly get it approved. EMD, performance guarantee, everything has to be crystal clear, and so that tomorrow we are safe in that eventuality. Now, as of now, the challenge is the evaluating of the resolution plan and its complexities. When we are giving the matrix, when I say the evaluating the plan means what we try to see to it that what is the maximum that they are giving. Now, what happens that if a company is having a liquidation value of 10 crore, assuming that, and if I and Mr. A and Mr. B are the PRS, A has given a plan stating that, okay, I'll be giving the money of rupees, say, 6 crores to the secured creditors, 1 crore towards the CIRP cost, and 3 crores I will pay, but that I will pay in tranches in so and so. 6 and 1 I am paying within 90 days. Another person has given that 10 crore rupees I am paying in 60 days. But there he has stated that all the collaterals will come to me, this comes to me, that comes to me. You need to understand the plan and its complexities, because people are very smart to just design their plan. I know that when I used to appear before the BIFR, we used to call it as their draft scheme. We have to just giving the draft scheme is to be given, and then draft scheme will become the sanction scheme ultimately once it's sanctioned by the BIF. Similar situation is now a resolution plan, slightly in a better format and better venom that they are doing it. But there also, as a RP, I have to evaluate properly, give a proper marking system, work out a solution, give it before the COC. Let COC decide if they want to change anything, criteria, any of that also, and then discuss with the PRS, try to carve out the maximum amount. Let the COC member along with you to discuss and find out that what is the value maximization. Because ultimately, me and you will not work like this. COC will have to take the maximum money out of, say, 10 crore rupees, 70 or 80% will be given to the only the secured creditors with my fees and my expenses, and the balance will go OCs. So ultimately, generality. I'm not saying always. I'm just telling you generality. So what happens that complexities are required to be understood properly. Plan is to be evaluated. When we make a matrix, we have to give a thought process behind the matrix and give the proper marking system. Then decide about it. Then also decide about that non-compliance in the plan submitted by RA. If the RA has not complied with certain things in his resolution plan, it is your duty to state. Or if he has given the plan with certain clauses or certain conditionalities, or it says that which is against any laws of the land, the plan may fail. So you have to either call the PRS, mention to him that this is against the law of land and therefore this plan will not be approved. So in that eventuality, it is your duty to see to it that ultimately plan should be complied with the IBC code. IBC code clearly says that if it is non-compliance, then it will not be there. We have to also prepare a Form H properly. If it is not been taken properly, the Adjudicating Authority will not entertain our application at all. So whenever we are approving the plan, or when COC is approving the plan, then it is me and you as RP will have to submit the application before the authority, state that this is the amount which they have offered. This is a Form H, and Form H is the final thing which any adjudicating authority will look into and decide about that the plan is complying with everything and therefore it's required to be approved or not. Again, while approving the plan, we have to take into account various judgments of higher forms, which are continuously emerging. Understand these enclave judgments in all cases. Assuming that it is basically for the purpose of payment of provident for gratuity, JETR-based judgment is also very important. Whether it is, the money is given to every creditors, means all the parties are being given something. It is also means various plans wherein the enclave as well as the Honorable Supreme Court has clearly mentioned that everyone should be given something. Maybe 5 lakhs, 1 lakh, 2 lakhs, whatever, but every party should be covered. So when we are just approving the plan, or when we are putting up before the COC, it is my and your responsibility that this plan should comply with all the lands of the laws of the land. A, B, the various judgments of Honorable Enclave and Honorable Supreme Courts are also required to be taken into account. Latest judgments, because of the fact that it is clearly mentioned that even if the RA has not submitted anything in his plan about the gratuity or PF of the employees, even then also he has to give over and above that plan amount, he has to give towards that. So this will definitely increase the cost of that. And then RA may say that I'm not interested, then you will be disqualified. Every blame will come to you. So only my humble request is, before going for it is your duty to explain them. Please look into this judgment. Please go to your legal lawyer and see to it that tomorrow you should not come back to me and create a ruckus. You have to decide about that, what way this plan should be there. So your entire chart should be ready, wherein you have to say that please comply with 1, 2, 3, 4 judgments of the enclave, 1, 2, 3, 4 judgments of the Supreme Court. State that this is the section 53, look into. Everything is required to look into properly, and then only you decide that yes, this plan is complying with everything and therefore it is required to be approved by the adjudicating authority. Because while approving the plan, adjudicating authority will ask that RP should remain present. Even before submitting the plan, you have to also give before the final hearing by the adjudicating authority, you have to give a notice to the income tax department also, that this is the plan which is submitted. If you want to object it, please give your objections to the adjudicating authority. So what my basic question is that you as RP have a lot of role to play as far as the resolution plan is concerned. Big impact from all the angles. But yes, it is not a problem. You can definitely take care of it. Now, you have to also look into that whether any possible collusion and unfair practices are there. Say basically what happens, collusions means the original promoter is disqualified or somebody is disqualified and tries to take over the assets of the CD, the company at an throwaway price, it is your duty to say that that should not happen. Practices which are not fair means if the relative distance relative of the original promoter, whether the promoter is a willful defaulter, then you also look into that he also should not be qualified. So these are the things which we need to look into, work out a solution. Every aspects we have to be agile. That do not try to have any collusion with them or any collusion of a PRA with the suspended management. Then also you have to be careful. Now, what happens? The belated claims after the approved resolution plans. Can you accept that? Answer says no. Because belated claims will have a direct impact on the resolution plan. Either the existing creditors will say that no, this claim cannot be accepted because of him, I am not getting full money or whatever I was supposed to get. Everyone is getting, say, 5% now, the belated claim is accepted, now everyone gets 4%. Why should I accept that? So this question comes again, the further application comes against you and you. If you do not accept also, they may go, but there your proper documentation will save you. That this claim has come after the approval result plan, therefore it is not accepted. Claims which are barred by limitation, assuming that claim which was 5 years old, none of the CD has given any kind of confirmation. Nothing has come and suddenly came after that. You say that this is already barred by limitation, not accepted. But for those, your proper paperwork should be there. You should know that there is no acceptance of the date. You can call for the purposes of the information from this promoter of the CD, suspended management. Ask them that whether you have given any acceptance of the date prior to this. Not given. So there also you have to look that is a limitation and therefore it should not be accepted. Then you are supposed to represent the holding company in the meeting of the all subsidiary company. Well, holding company is under CIRP. Look at that. A company is in CIRP. A as a X as a holding subsidiary company, X, Y, Z, 3 subsidiary companies. You as a RP will have to just go and attend the meetings because it is you who are the in charge of right now the CD. So this is the aspects which we need to understand. The more challenge is the raising of the interim finance to keep the CD as a going concern. Existing creditors may not offer that, particularly the smaller companies, this is a bigger problem. But there also you have to carve out that what is the liquidation value and first money should go to him, provided if it is a going concern, it will fetch this much money. If it is not a going concern, it will fetch this much money. Then only the difference of the money you can raise at a lower rate if you want. Otherwise, do not try and just raise it, let it be. But when you want to keep it as a going concern and if you have to raise the finance, interim finance, you have to be very careful about that. That interim finance cannot be given by anybody except either normally the existing lenders or the person who gets the proper, he understands that there is a real cash streams against which his money is secured, then he can give it. Robust system and proper checklist for handover charge from IR to RP and RP to liquidator. What is happening? I have seen this also. There is no system of handing over the charge. When you are giving the charge to the from IRP to the RP, first of all, we as a professional brothers should not have any kind of any problem when you do not be you are not appointed as a RP. You have to always accept it. From A to B it goes. There should not be any bitterness in the mouth of A, or there is no even enjoyment in the mouth of B, because of the fact that we are professional colleagues and professional brothers. While handing over the charge, you should have a proper checklist for that. You should have a proper writing of this, because tomorrow the RP will say that you have mentioned that there is an X asset lying here in the company's premises, but when I took the charge, there was no assets. No, you have to be very clear and careful that whatever you say, you show it to him, take a proper videography, hand it over, and then work out. Make a proper checklist of it. There has to be a this what is the auto process, handover takeover process should be a smooth process, as smooth as what is required. And say for example, company goes to liquidation instead of the it because there is a resolution could not take place. Then you know that nowadays the liquidator is required to be changed. You are not becoming a liquidator. So RP is required to give the charge to the liquidator. While handing over, you should have a proper checklist. you to also mention that this is the money which I is due from COC members towards my fees and my expenses. And therefore, it is required to be, because these are ratified by the COC, but not paid to me. So, and or paid up to this much days, and thereafter it is pending because the fact that the company went to liquidation. From that day, they have stopped making the payment. So my request is, I need not to go to the AA for the purpose of recovering my money. So you, as a liquidator, please see to it I should get the money. So my only humble request is, while doing all those things, your checklist should be proper, your clarity should be there. And if not, they give COC, then you have to also file an IEA for the purpose of recovery of your money. As I said, that 29A also, your system should be proper. That you should check all the provisions of 29A, do the proper diligence, take the help of the other professionals if required, and then decides about that. However, during the CIRP also, as an IP, there are a lot of other things which are coming in our way. Assuming that you have to go for a police protection and there is no direct cooperation from the existing promoters, you cannot directly go to the police and ask for it, but you have to go to the education authorities, take the order, go to the police. Even if the police has come and look into that, if the erstwhile promoters are very powerful, you may not be able to get the adequate response, then you can go to directly the DGP, CP, or whosoever may be. From there, you get the proper protection. So it's not like that always is that simple. It's not a cakewalk. However, I mean, having said that it is not cakewalk, does not mean that you should not make the efforts. You should, first of all, you should know all the acts properly, your rights, your how you can derive the rights also you should know. Then only you will be able to do the needs. Now, I think that we have taken about 2.5 hours. Any questions? Then let us try to ask everyone that questions. If I can do otherwise, you can write the questions to me, and then I will reply for or through your mail, whatever the case is the case may be. If you want to ask some questions about this, I leave it up to the audience to do it. If anybody has found out any problems during the course of CIRP.
I have a question regarding non-cooperation.
Yes, sir.
What is your overall experience on Section 19(2) application?
Ji.
I mean, does it really help practically for getting the desired cooperation and getting the
As
documentation?
I told you initially, and I reiterate also that what is happening today. If I am sitting in my office and somebody says that tomorrow onwards that you are no more a owner of this office, I will sit in your place. So definitely I will feel a pinch of it, and I will always feel a nausea against that person. It is a standard Indian mentality, whether one likes or not. But yes, in spite of this, you have a legal remedies. You cannot tell that person that you get out of this, and you cannot have a muscle power. But at the same point of time, you just go to the AA, state that these are the things which I'm not getting. What my request in that eventually, what you should do is you just define that duties also, because you are entitled for duties. Today, your entire assets are there. I have taken the possession of the assets, but now you're duty bound to see to it that you to protect the assets. You put the duties on him, cast the duties and write down to him and get the letter from him, give a letter to him, signing by yourself and then countersigned by him. See, all those things will protect you, and then he is bound to give the cooperation. And if he does not give, ultimately the police, you just go to the education authority, get the police protection and get it done. I'm sure that the education authority is passing such kind of orders every time. So practically, yes, AA properly, you have to just immediately you to act to the AA, try and work out and then do it. See, somebody will say that I am in my office, I have another 3 office going on, so therefore I will not go because my 2 companies are running from here. Therefore, I cannot give the possession. The AA will say that no, you have to give, just shift this office, your other offices from here to others. You're not paying any kind of a rent. This is a city's office. So basically, what my answer is that depends upon the circumstances. You have to go to the AA, ask for the proper relief from that, give a proper application, make it that this is the urgent application, and then only you work out a solution. I'm sure that they will have to do it. And they give us. In so many cases, I've seen that they are giving a police protection, and from that, we are getting the things done. So I thank you very much for your patience hearing. Thank you to everyone. If you have still any other questions, you may write down to the ICSI, and from there I will reply. Thank you so much. Thank you.
Thank you, sir.
Thank you.
Yes, sir. हेलो हाँ देखें ठीक है
Is there anybody from ICSI, IIT? To quote vote of thanks? Shall we call it a day?